Justice Barrett?
My question's on the law-abiding and responsible also. I guess I understood our use of that phrase in our prior cases to describe the would-be gun owners in those cases. Like, we're not talking about who might be able to be disarmed. There might be other people, but all of those people were law-abiding and responsible, and there was no allegation that they weren't. But it seems to me that in your brief and in parts of the argument, the government is asking for that to be a test, but I don't think we presented it as a test. Do you see a reason for us to use that as the test, law-abiding and responsible, given some of the ambiguities in that phrase?
So I wouldn't describe it as a test. I guess what I would do is describe it as the relevant category, the shorthand to get at the idea that legislatures consistent with the Second Amendment can take action to disarm particular types of people whose possession of weapons present these types of concerns, either that they have committed serious crimes or present a danger. And I would use this as shorthand in the same way the court has referred to the sensitive places principle or the dangerous and unusual weapons principle.
So could I just say it's dangerousness? Let's say that I agree with you that when you look back at surety laws and the fray laws, et cetera, that it shows that the legislature can make judgments to disarm people consistently with the Second Amendment based on dangerousness. Why can't I just say that?
We certainly agree that that's what history and tradition show. We think that defines the scope of the category of those who are not responsible. We don't think dangerousness is the standard with law-abiding, and I recognize you might have some different views on that, Justice Barrett. You don't need to resolve that issue here. This is a case just about someone who is not responsible in the form of being dangerous. So yes, we would be happy with a decision that says legislatures for time immemorial throughout American history have been able to disarm those who are dangerous.
But you're trying to save like the range issue. So you're not applying dangerousness to the crimes.
That's correct. We think that there are additional arguments that can be made to defend felon disarmament, and that those depend on the unique history and tradition with respect to criminal conduct. And so we would hope to have the opportunity to present those arguments and perhaps
that case,
persuade you in a future case.
Okay.
Yes.
Thank you.